We're with David Shapiro. David is a criminal defense attorney in San Diego, California, and he's agreed to answer some online questions that were posted related to child molestation and some of the defenses available, etc. With that said, David, let's get into the first question. Are there mandatory times for child molestation charges?
Mandatory times, assuming the question is mandatory jail times, and the answer to that is yes. A lot of those offenses could be based on the allegations and the specific allegations legally attached to them. Could be mandatory state prison cases. It could be mandatory indeterminate lifetime sentences. What I mean by that is, let's say, for example, you're convicted of molesting more than one child under the age of 14. It would be 15 years to life on each. Could be consecutive, could be concurrent. But if the prosecutor were to file and if it were to be proven you molested more than one child, you'd be looking at a lifetime sentence, meaning it would be a determinate period of time or a set period of time to life. And usually on these types of cases, particularly in California, it means life if you get a lifetime sentence. You also have to worry about something known as SVP. To be deemed a sexually violent predator upon your release from prison would be a civil commitment indefinitely, which is a whole other issue that needs to be considered when trying to negotiate a resolution, if you're able to, and if that's in your client's best interest in these types of cases. So there's definitely mandatory minimums. There's definitely mandatory prison offenses. There's definite mandatory lifetime offenses, all important, all emphasizing the need for a quality attorney on your side.
All right, next question was the charges on me are for sexual conduct with a minor, but they have been dropped by the girl. Does this mean the state will stop pursuing me?
No, especially with allegations of sexual nature involving a minor. What the girl wants, should be considered, but is not the end-all, be-all. Once it comes to the attention of whether it's child welfare services, whether it's a school, whether it's, in this case, it appears it got all the way to the district attorney's office. They're going to run with it, irrespective of what the child wants, because just as they believe, assuming this was a consensual encounter, they're going to believe that the child lacked, and they're going to argue legally, and they can under the law, that the child lacked the capacity to consent under the law. That's why stuff like statutory rape and all that, it's like, hey, she's 16, she consented. Well, legally speaking, as archaic as it may sound, that doesn't work. That defense doesn't necessarily fly. And they're just going to argue the same way that, this is what she wants. She doesn't want you to be prosecuted. That's fine. But the crime the prosecutor should argue is not necessarily against her. It's against all of society. That's why they refer to themselves as the people of the state of California. I usually get a kick out of that sometimes because my experience is a lot of times the people of the state of California wouldn't necessarily prosecute cases the way the district attorney's office does. But the alleged victim's input is something that they have to consider under Marcy's law, but it's not something that they have to adhere to. It's not something they have to follow. So, you have big time issues on your hands, irrespective of what this girl wants.
Understand. Okay, and the next question we had, this is not very specific, but it just says, will I have to register as a sex offender?
Well, that depends. If you don't get convicted of anything, no. If you get convicted of certain offenses that are designated as mandatory lifetime registration, then yes, and it is for life. There are other offenses designated basically PC 290, Penal Code Section 290.006, I believe, which basically is discretionary registration, ultimately be up to the judge. For judges sometimes impose a definite period of time, whether it's, they can do it for life. Sometimes they do it for the term of probation. There's some dispute about whether they can even do that legally because the language in the sex offender law says shall register for life. So it's hard to see how a judge could get around that. Some attorneys try and negotiate that, and it just doesn't usually end well. It depends on the offense. Certain convictions and certain offenses that if you're convicted of that, the judge's hands are tied. Even if they didn't want to, you would have to register. It's important that you have an attorney that knows what they're doing, certainly enough to be able to advise you accordingly if you're trying to work out a plea bargain or if you're trying to go to trial to avoid lifetime registration. It's important to know what you're charged with, what the options are, and how mandatory registration for the rest of your life would be in the event you're convicted of those offenses.
Okay, and the next one again it's not very specific, so I'll go ahead and give it to you. Does Megan's law apply to me?
Well, depends. Depends on what if anything you're convicted of, and it depends on the level of registration and everything else you have to do. So the best thing you could do, assuming you're convicted, is ask the attorney who represents you about the specifics of it. If you're currently on probation, you want to run it by them. If you're on parole, you want to run it by them, and then obviously consult with the attorney who previously represented you. If it's a situation where it's a conviction from years prior, then you want to get the record of conviction, as many documents as possible from that time, bring it to a qualified, locally experienced criminal defense attorney who could advise you accordingly what your options are and to what extent you need to register under the law.
Okay, and this is the last question we had for you was how do you charge for child molestation cases?
Well, generally speaking, we set a retainer agreement, and that retainer agreement generally does not include trial, but that's assuming you hire me from the front end. Now, if the case is set for trial and you've had a prior attorney up to this point and you've already done the preliminary hearing, then usually I get hired for trial, which means we could resolve the case favorably with a couple of court appearances, or the representation would include the entire jury trial. Other times people call my office and they haven't been charged yet, and they may not even be contacted by law enforcement, but they might hear a rumor out there. They may be fired from their job, or they may be fired from their work at place of employment if they're a teacher and they're accused of having impropriety or improper actions with the minor. And then we'll do it on what's known as a pre-file basis. It will not include court, and the goal is to avoid court. So it'll be significantly less of a retainer agreement required than if the case is already in court, and certainly less than if the case were to proceed to trial, because as someone who's tried these types of cases before, I know the time commitment leading up to and certainly during a trial of this nature, how much time, how much effort, how much my practice we need to shut down to give 100% attention, basically 100% of the day, to your case, and the case proceeds to trial. So generally speaking, a pre-file basis before charges are filed, once charges are filed, but not including trial unless you want to, and then including trial. Usually those are the three general rules for all cases, specifically as it relates to these serious types of felonies.
Okay, excellent. Well, if you have any other questions for David, you can all you need to do is post them in the comments section below. He's agreed to get back with questions or with answers. With that said, David, thanks for your time.
Yeah, my pleasure. It's important to note, though, especially if you're charged with felony cases, if you had the means to hire a quality attorney or fire the attorney you're currently hired and hire somebody else, try and do it before the preliminary hearing. A lot of times, we get hired on cases that are after the preliminary hearing, and you're kind of trying to undo somebody else's work. You might not approve of their style. You might not approve of their tactics. You might not approve of them as an attorney. So if you have the resources to do so, get on it early. Keep your mouth closed. Don't discuss the case with anyone except for a quality attorney, and let them help you and let them prevent a lot of the damage that might be coming your way.
Thanks for your time.
You got it. My pleasure. Thank you.